couple of questions and cross discussion before we go to you, and we do have some time here. It's just 4:15. Valerio, you mentioned that there are a number of nations that grant collective bargaining rights to independent contractors. I presume some are in Europe. Can you just name a few, just so we can, again, inform our sense of national backwardness? But what are a few that do that?
Germany, Italy, Spain, I think Australia as well. Mm-hmm. Now, there has been a judgment under the Court of Justice of the European Union, so the Supreme Court of the EU, if you want. And the court said that self-employed per se are not allowed to bargain collectively because they breach antitrust law if they do so. But the extent to which this is going to be enforced in these nations where these laws have been adopted is still to be seen. So there might be a conflict between the national and the European level, but it doesn't mean that this is not possible after that judgment anymore.
Thank you. Ben, your example of the New Haven Hospital, A, I knew about it, and B, it rang some bells. In the city I called home for almost half a century, Los Angeles, there was, at least as far back as the 90s, conditions were attached to most major projects that were going up in terms of, ultimately in terms of unionization, what that would take. Initially with the construction workers, but then at the behest of the LA Alliance for a New Economy, it employed to retail workers and the development that was being built and so on. My question to you is, do you have examples of this kind of tripartite back and forth which allows ultimately for worker changing the rules that aren't related to city permitting of construction? Because what you said and what I have in mind all basically are within that subset. So are there more?
Yes.
Okay.
Yeah, would you like to know them now?
Yeah, sure.
I mean, I think that some of SEIU's work in the nursing home industry in California can be understood in this way, and it was not construction. So it was instead of permitting, it was increases in Medicaid rates that the union pressed for, and that was obviously in the also in the interest of the industry, and was tied to in one way or another an agreement around organizing rights.
Okay. I'm reminded of the Vegas, the magnificent Vegas hotel local getting an agreement with Steve Wynn to unionize his hotels since they lobbied for high-rolling foreign gamblers being able to keep their dough. But the government wasn't involved in that.
Yeah,
that
I mean,
was,
the important thing for this model is that there's some non-labor governmental action.
Right.
So like CWA has done this with telecommunications permitting. Which is actually not state and local as I think about it, but the point is, it often has to do with construction permitting, but is not exclusively.
Okay. Do any of you have further thoughts on this model of, as it were, changing, or rather legally evading federal preemption? David, do you have some thoughts on this, since this is some of the stuff you've been looking at?
It's clearly one of the strategies. But as Ben was implying, it depends upon the political power of the union in that local and having an employer who needs something, and that's not necessarily applicable everywhere. Although I think the concept is certainly something that can be thought of creatively, and we are in a spot where all our efforts need to be at the state and local level. There's either, to me, all our efforts are defending what we've got and building some power at a state and local level, and it's clearly one of the strategies.
I mean, and obviously our work around procurement at the federal level is a variation on that, and using the government's procurement power to enforce labor standards that we couldn't get through federal legislation. So it's a similar play.
I'm struck by what I take, my understanding, which is to be based on inference, of Donald Trump's deal with Carrier, where I agree with something Steve Greenhouse wrote in a piece for The Prospect earlier this week, that the carrot was so limited, the stick had to be really there, of losing federal contracts. And again, the power of contracting becomes, A is obviously major. B, if, that is a weapon one way or another government can use. And I think one of the things that we might look to be hectoring our president-elect as he becomes president is not merely using, what Trump did in an odd way was an extension of the DOL's,
fair pay, safe workplaces,
saying if you're a federal contractor, here are your rules. And since we are presumably concerned in a Trump administration with its vow to make things better for, in Trump's case, white workers, but we could, we ourselves say all workers, if he's selectively dealing with the federal contracting as leverage, we should be pointing out that even as he defines his narrow set of concerns in the workforce, that we should adhere to more leverage on contracting than simply the offshoring question. Kathy, do you share Ben's sense? This was perhaps implicit in what you were saying, that the courts are, in many ways, our best avenue to deal with some of these questions, and in particular, employee status in going forward?
Yeah, I definitely agree that we have been using the courts, and we need to use them more to establish and even stretch some of those definitions into more modern examples. But I do think, there's state agencies out there that are enforcing labor standards laws, and they can and have been exercising the kind of leadership that David Weil and David Michaels and others at Department of Labor have around the scope of the breadth of their state laws, and they're enforcing against the Ubers of the world that are trying to wipe the slate clean and say that nothing fits their model anymore. But it is true that in the labor standards context, at least, private enforcement has been about at 90% of, because Department of Labor has resources and it's very strategic, but it's not engaging in the court. So I think it's an increasingly important tool. We're organizing the private bar to make sure they're pushing it and doing it. So yes, I totally agree with Ben's assessment.
Yes.
Can I add one more point to the procurement point that was sort of brought up as a strategy here, and I should have mentioned it myself, but this one, you have scope with procurement. There are sort of estimates, at least in the roughly 1 in 5 workers work for a company that contracts with the federal government. And then if you think of grants, loans, et cetera, you get well beyond that. And then the state and local, I think you are getting, so you don't have the same exact scope as direct policy that we're talking about, laws that apply to all employers, but you really do have some leverage there. And also the legal precedent seems to give a lot more room for state and local governments in their role as market actors than as, or at least gives them, it gives them a fair amount of room in their role as market actors as opposed to just regulators.
Okay, let's take some questions.
Hi, Patrick Rayner. I'm a Precarious employee in Montgomery County currently as a substitute teacher. What I wanted to ask you is one of the policy changes that I think that we really need to make that hasn't been addressed at all is how we report labor statistics. I mean, a part-time barista counts exactly the same as a doctor laid off by Kaiser. I mean, it's ridiculous. And the people knew we were telling them, oh yeah, it's all great. And the labor market is, we're employing all these people. The people knew they were underemployed. They knew they weren't getting paid what they were getting paid before they took their barista job. And that was one of our problems. The other one is the 29-hour work week that's become the 40-hour work week has become the 58-hour work week. Because people like Olive Garden and all that are only hiring people for 29 hours so they don't have to give them the medical care from the Affordable Care Act. So what do you think we can do on those two fronts? Or Ms. Block, is there anything being done at labor to change the way we report our statistics so it's more realistic?
Sure. So one thing we're doing is that we will be running the contingent work supplement again, so that we'll have a better idea. I mean, there's sort of a cottage industry of throwing out numbers, trying to describe the size of the gig economy and this contingent workforce. So we will be doing that. It'll run in May 2017. Obviously, beyond that, we only had the funds to be able to do it for a year, but we would have hoped that it would have continued because it is so important. I mean, exactly what you're saying. Can't make good policy without understanding what the numbers really are.
Okay.
Can I add?
Yes, please.
On this, because I think this is
Speak more into the mic.
crucial. That we need to have some clarification in how we count people in contingent working on standard work, because there are a lot of numbers out there and reports that say that people are so happy to be independent contractors, and basically they count together a traditional lawyer with a Uber driver with a temp at Starbucks. And they are together inflating this big category of we don't know what, but basically these numbers are normally used to drive deregulation and try to establish the idea that it's so great to be independent. And if you go and look at the questions that are done in this survey, it's like how people value to be an independent contractor, because they ask questions like, would you want a 9-to-5 job, or would you like to be your own boss? I mean, of course I would like to be my own boss, but that doesn't mean that I don't want to be an employee. It's a totally different story. So we desperately need reliable numbers.
Good point.
I just want to echo
Yes.
something Kathy said, which is you can be an employee and be flexible, or you can be flexible. You can have a flexible work life and still be categorized correctly as an employee under existing laws. So I think you don't need to take away the ability to have a flexible work relationship and lose employee status.
I'm struck by the fact that several of you have emphasized the fact that these definitions of employment under federal law encompass more workers than most people think they do, and therefore, or not therefore, I'm struck by the fact that most of the discussion, if not all of the discussion about the growth of these sectors hasn't factored that in at all, and that this therefore becomes one of the many discussions in the United States that is proceeding from premises not only that are wrong, but are based on the fact that very few people know this. I'm just struck that the way in which, therefore, the whole discussion is. I mean, what do we do? What do we, other than waging individual cases in court, which is not a particularly good. It's a way of winning things, but it's not a particularly good way of changing the public discourse. Any thoughts on changing the public discourse on this?
Yeah, I mean, I'll start on that. I think we are losing that battle in the media, and I think when you sit down with a judge or with a mediator and you explain the purposes behind the remedial legislation, why they're there, why they're intended to cover most workers, it's pretty easy to turn them around and to get there. But they also think it's control over how the work is being done. That's what they think. It's kind of like pornography. They think they know it when they see it, and they don't. So I think it takes a lot. You can do it on one-on-one conversations. Part of the reason we did the HART contract and the messaging and the polling was to try to get at some of these stories and understandings. I think that, if you read the UK's Uber decision that just came out, they eviscerate Uber and the notion that there's any question at all that these workers are actually running a business and as an independent contractor. But so I think we just have to keep training in on the facts, keep telling the stories of how the myths around flexibility equals independent contractor, that the workers like this job. We just have to keep at it, and we do have history and facts on our side, so we just have to keep doing it, not just in litigation.
Okay. David?
One of the reasons why I've been feeling upbeat for the last 3 years or so, aside from the fact that people like Kathy Ruckelshaus and David Weil and others have been doing such great work, is that it seems to me that the rise of the precarious labor, as Leah Vasco said earlier, has a gender dimension. A lot of the new forms of work make it almost impossible for women to fulfill all of the gender roles that they want to fulfill and the other social roles that they want to fulfill. And it seems to me that that conflict has to produce pressure for change in the way our employment system is set up now. And I was wondering whether that is reflected in any of the work that the 5 of you are doing.
I can start a little bit. I mean, we've been very conscious of that dynamic, I think, especially around the minimum wage campaigns, trying to really get people to understand the face of a minimum wage worker, that it isn't, I mean, talk about dispelling sort of popular myths, it isn't a teenager trying to earn extra money to go to the movies. The face of minimum wage worker is a woman, often a single mother with a child trying to support a family. And so throughout the administration there have been CEA reports on sort of profiling what a minimum wage worker looks like. What is that profile? In terms of just the bully pulpit that we've used, we often, especially around tip minimum wage workers, really focusing on trying to dispel those popular myths and getting people to understand who these workers are and why they should care, and sort of, again, that ripple effect of what it means to not support these policies that help workers in these sectors. I mean, home care is a perfect example. I mean, there you really can't avoid sort of the gender aspect of the impact of our rule, extending minimum wage and overtime protections to home care workers, because they are overwhelmingly women workers.
Okay. Are you to my? Yes, you are.
Yeah, just a brief...
and let's have people identify themselves, even if they've already identified themselves, as in this case.
Jeff Wheeler, Department of Labor.
Right.
Just wanted to note and highlight the procurement requirement issue at the federal, state, local level. There's a lot of work, a lot of promising efforts going on there. There was the Sustainable Procurement Leadership Council meeting here in DC a while back. I serve on a panel, the EP panel for Electronic Procurement Assessment Tool, which is setting new labor as well as environmental requirements in supply chains. DOD buys into this, GSA, others, and now we're seeing more of this replicated at the state and local level. It has been just environmental so far, but now we're doing labor and OSH. There's an upside, get engaged in it. The potential downside is that the means of verification is too weak while the principle is there. But it's a very promising area to look into at the state, the local, the federal, even the international level. Part of it is it may survive because it's collaborative with industry, which is both a strength and weakness.
Okay. Any further? Yes.
Hi, my name is Caitlin Lacey. I'm currently with the Teamsters here in DC, but formerly with Good Jobs First. And thinking about action at the state and local level and how to use development projects as leverage to get better job quality standards, wanted to point out the work of Phil Matera and Greg Leroy over at Good Jobs First. And they have been trying to call attention to the fact that new accounting standards are now required. Reporting starts this year. That state and local budgets are now required to disclose, if they want to be GASB compliant, the amount of revenues lost to tax subsidies and the like. And that's a huge tool because it's transparency and accountability and in spending, but also as this point of saying, hey, this is how much is being lost, what are we getting for it? And pointing that out as a tool to sort of hopefully get better deals for workers and as an opportunity. So, thanks.
Okay. Mark.
Mark
Who are you? Yes, go
Mark
ahead.
Levinson, SEIU. I hadn't even thought of this until I think Ben Sachs mentioned it on the panel. But given where we're at today, I'm just curious what people think. If federal preemption were, what do we think? If it was proposed to be abolished, what do we think of that, given where we're at today?
Do you mean what I think? What do I think of it?
Yeah.
What-
Would it open up possibilities, obviously in parts of the country that are cut off today, in some big parts of the country?
Yeah, I mean,
that would obviously be disastrous in other parts, but like it's. I'm just curious, what do people think of that trade-off?
I think I would almost say I'm not the right person to answer the question, other than to say it's a trade-off. The analysis would be essentially, would the decline in union rights in places like, I mean, Arkansas, Oklahoma, be correct? And would that be balanced off by gains in California, Illinois, in New York? The rosy story is you get real gains in a place like California, which you can then ultimately export nationally. It would be there's a. It wouldn't be. It's not just a legal story, which is why I'm not necessarily the one to answer it. If 3 states in the country had incredibly robust union protections, you might see more capital flight from those states. I don't know. It's possible. My gut feeling is, given where we are and given what you just said, which is it couldn't get that much worse in a lot of the country, that this would be a good trade. The problem with that position is if it's a good trade, it's unlikely to come to pass. But I think it's in the end an empirical question that's really worth thinking about.
And we have a little bit of an experiment, right? Because the one area that we don't have federal preemption is right to work. And I think it's worth looking at, sort of to the capital flight question of, at least most studies I've seen, you don't see a big increase in jobs in states that have recently become right to work, because they're obviously much bigger forces in effect. So I think, but we've also seen a lot more right to work, obviously, in recent years. I think you want to look at what the effect of that has been in drawing jobs. And you'd want to make sure that experiment can tell you something about what you would expect if you pulled back preemption even more.
I think so. I think Richard Freeman has a paper where he argues that
He does. Yeah.
Yes. So makes the argument for that actually union density would increase under the scenario you described. So worth looking at that if you want to. But to me, look, we're not actually negotiating policy here. But if we were, the kind of principle you'd want would be like what we have for the minimum wage, sort of progressive federalism, where you have a floor and then the ability for state and local governments to go above.
I totally agree, but that we would clearly not get that.
No,
That's what. No, right. So I totally agree with that point. I think that the interesting question is, like, if to get a trade like this, I think the two sides would both have to think that they were right and that they were going to win, and that would be an unusual set of political circumstances. But it's not impossible that it would pertain in this with this question.
Well, I was going to say what David said about the federal law providing a floor beneath which the states can't drop. And it may be that that's where we want to start, because there is going to be a movement for national right to work. There's going to be a lot of other things, and we may just want to start with an affirmative, aggressive federal agenda that includes some of these things, even if we think we're not going to get them.
And Mark, since this is a political question, and since this is what I write about, let me do something a little harsh, reality therapy. I mean, there really only are 5 states right now where Democrats control both houses of the legislature and the governor's office. There are a couple hanging by a single legislator: New York, Washington, Connecticut. Yeah. Well, okay, but we could not get this through in Illinois, Massachusetts, and Maryland because there are Republican governors. You need to understand that the push against unions at this point from the Republicans comes really less because of any apprehension about how they're going to affect the economy. In most states, private sector unions barely exist. It's political. They want to get rid of unions because unions work for Democrats at election time. Now, we do control most big cities, overwhelmingly. 90% of the 30 biggest cities are Democratic government. There's a limit to what you can do on this stuff at the city level. I mean, an Uber driver who crosses a city line, and in one city he's covered, and in the next city he's not. That's very tricky. I mean, so states are really the ballpark here, and we only have a few states where I think where this could work, and most notably my good old home state of California, which would see a major increase in unions. But I mean, we're really seriously at the point where the divisions between blue states and red states on a host of issues are growing wider and wider and wider. This would be one of them. I think, given the current balance of power, and given the fact that most state elections are held as midterm elections, which, in terms of turnout, favor the Republicans, I wouldn't go there for that reason. We're just not going to control that many states for a while yet. So this may be a great idea, after the 2020 census and the redistricting. I would hesitate now, because I think there's too many obstacles at the state level to getting many states that would actually increase workers' organizing rights under that kind of a deal. Just to depress you further. Okay, further comments, Leo? Are we okay? Let's thank the panel for really informative discussion. And hear from Leo Casey to wrap up.
I'd like to thank not only this set of speakers, but the speakers we've had all day. I think it's been a really very informative and thought-provoking day. Particularly like to thank our speakers who traveled internationally to get here. I think it was, as Americans, we tend to be somewhat insular in our thinking, and I think it was really useful to have some thoughts from other parts of the world. I need to thank, although she's undoubtedly hiding somewhere, as she always does, Vicki Thomas, who made sure all the speakers got here and everything went off on time. And I thank my colleagues in the Schenker Institute. And lastly, and most importantly, thank all of you for coming and helping make this an important event. We are clearly headed into some difficult times, but I think the sort of work that we've done today in terms of thinking how we face those times and what is the space that we have for interventions and how do we move forward in a strategic way, this sort of work is the essential work for the times we have today. And thank you for coming here and being part of it. Have a good trip to wherever you're going.